Hello everyone. I welcome you all to the theme Vidhi Vani, which means voice of law. In continuation to our efforts to discuss on various questions of laws under this theme, today we are going to discuss on a very important question or concept, that is whether a LLP is allowed to be merged with the company under the Companies Act 2013 or not. Friends, why this question is important to be understood is because when we refer and compare the provisions of the merger and amalgamation in the erstwhile companies in 1956 and compare it with the provisions under the Companies Act 2013, there is a significant shift in the concept. Starting with referring to the provisions of section 394 and more specifically subsection 4 clause B of that section, it can be interpreted that in the erstwhile Act 1956, the mergers of LLP and the company was quite possible. But when we refer to the provisions of section 232, it says and talks about only the merger of the companies, and there is no express provision alike the Companies Act 1956 in this particular provision of section 232, and therefore the LLP is not allowed to be merged with the company. But again, we have to refer to the law as a whole. Going further in the same chapter under the Companies Act 2013 and referring to the provisions of section 234, it is allowing the merger of the foreign body corporate, be it company or not. It may include LLP also. It is allowing the merger of the foreign body corporate with the Indian company or vice versa. Now there is a confusion. First school of thought says that you have to go by the literal interpretation, and therefore by going by the literal interpretation and plain reading of section 232 of the Companies Act 2013, the mergers of the companies are only allowed under the act. And since there is no express provision regarding the merger of LLP or body corporate into the company under this act, it is not possible. Since there was express provision in the erstwhile Companies Act 1956, it was allowed there, but in the provisions of section 232, since express provision is not there, it is not allowed. The second school of thought says that going by the purposive interpretation of the law and looking at the system as a whole, the regulator for the LLP Act and the Companies Act is the same, that is the Ministry of Corporate Affairs. Secondly, that the approval authority in the cases of merger and amalgamation under the LLP Act and the Companies Act is also the same, Honorable NCLT. And also furthermore, going to the provision of section 234, which is allowing the mergers of the foreign body corporate with the company or vice versa, it is very difficult to be presumed that the intent of the legislature is not to allow the mergers of LLP into the company. And since there is no specific bar on this particular concept, this can be allowed. So these are the two school of thoughts, and therefore there is a confusion. So now I'm going to discuss on a very interesting case law, that is of Real Image LLP and Cube Cinema. In this particular case law, the Honorable NCLT has allowed the application for the merger and amalgamation of the LLP with the company and has applied the principle of casus omissus. Now looking at the whole provision and also comparing it with the erstwhile companies in 1956, it can be interpreted that there has been a omission by the legislature to mention expressly regarding the merger of LLP with the company. And since there is no specific bar, it can be allowed. Now furthermore, the Honorable Regional Director, going further in this particular case, Honorable Regional Director has filed the appeal before the Honorable NCLAT and has contended against the impugned order passed by the Honorable NCLT Chennai bench and has argued that Section 232 is allowing the merger of the companies only and not the LLP with the company. He has also referred to the provision of Section 366 in his argument, that is of the Companies Act 2013, that expressly provide for the conversion of the entities registered under different act to get converted into the company under this act. So he has argued that the LLP has to first convert itself into the company and then it can avail the provision of Section 232 for the merger, otherwise not. To which, after listening to the argument of the Honorable Regional Director Southern Region, the Honorable NCLAT has concluded that the Honorable NCLT has not rightly applied the principle of cases omissus. It cannot be applied in such cases. And for applying of this principle, there should be a clear necessity and the law should not be providing any other recourse for the same. Then only this particular principle can be applied, otherwise not. And Honorable NCLAT has set aside the order passed by the Honorable NCLT and has clearly conveyed that the merger of LLP with the company is not possible under the Companies Act 2013. Therefore, friends, to conclude, we can say that legally as of now, the merger of the LLP and the company is not allowed under the Companies Act 2013. But in my personal view, there should be some recourse very soon to be interpreted in this particular law, and the express provision or the clarification should come on it. Thank you so much once again. God bless us all. Thank you.